Run Technology Services is registered in the BVI. We are a consultancy firm that provides technology services. This video, voiceover, is a true translation of the British Virgin Islands Commission of Inquiry report of the Commissioner the Right Honourable Sir Gary Hickinbottom. Presented to His Excellency John James Rankin, CMG, the Governor of the Virgin Islands, April 4, 2022. None of the information from the report was not distorted and was transcribed as reported by the Commissioner. Chapter 14. Overarching Recommendations. Introduction. 14.1 On analysis of the evidence, many of the conclusions set out above were not difficult to draw. The state of governance in the BVI is appallingly bad. In all the circumstances, including the absence of any acceptable explanation for that state and the way in which elected public officials continue to shun the basic principles of good governance, knowing that that gives rise to an environment in which dishonesty in and around government can flourish, the evidence would drive anyone who is impartial and independent to the view that the conduct falls within paragraph 1 of my terms of reference. The conditions which allowed this state of affairs have not changed and, as things currently stand, are likely to remain unchanged for the foreseeable future. 14.2 During the course of this COI, participants have often sought to show that a particular part of the evidence does not show poor governance and/or dishonesty in public office. Although they have usually been unsuccessful, and I hope any errors in this report are few, I should say that the information before me paints a picture that would not be undermined by any attack of part of it. The evidence is enormous. Looked at as a whole, it is in my view overwhelming. It irrefutably paints the picture I have described. 14.3 However, I have found some aspects of the recommendations, which my terms of reference require me to consider, to be more difficult. In my view, the overarching recommendations I make should not simply reflect what I consider to be optimal, but what I consider essential in the public interest, i.e. in the interest of the people of the BVI. 14.4 After the most careful consideration, I make 4 primary recommendations. I consider each essential. 3 look forward. 1 looks back. Temporary partial suspension of the Constitution. 14.5 First, and with a particularly heavy heart, I have concluded that, unless the most urgent and drastic steps are taken, the current unhappy situation, with elected officials deliberately ignoring the tenets of good governance giving rise to an environment in which the risks of dishonesty in relation to public decision-making and funding continue unabated, and the consequences of allowing such an environment to flourish, will go on indefinitely. That is wholly unacceptable. It is not simply that the people of the BVI deserve better, which they do, but the UK government owes them an obligation not only to protect them from such abuses, but to assist them to achieve their aspirations for self-government as a modern democratic state. I have concluded, with some considerable regret but ultimately very firmly, that for the current situation to continue would adversely affect those aspirations by delaying, or even entirely preventing, progress towards such self-government as a modern democratic state. 14.6 As will be clear, the problem lies with the role played in government by elected officials. I have most anxiously considered action short of temporarily denying elected officials that role by a partial suspension of the Constitution. However, although of course I do not say that all elected officials are dishonest, the information of conduct falling within paragraph 1 of my terms of reference spans different administrations and different parties. As things currently stand, I could have no confidence in a future elected government re-establishing adequate governance or bringing to an end the conditions which favor dishonesty involving public office holders. As I have indicated, my findings in relation to governance etc. apply equally to the previous NDP administration, and the Constitution as it is currently framed lacks the robustness to prevent such conduct in the future. 14.7 Therefore, whilst I appreciate that the Governor and the UK government will consider this only as a last resort, as do I have concluded that the only way, and I stress, the only way, in which the relevant issues can be addressed is for there to be a temporary suspension of those parts of the Constitution by which areas of government are assigned to elected representatives. It is only with the most anxious consideration that I have been driven to the conclusion that such a suspension is not only warranted but essential, if the abuses which I have identified, which are abuses against the people of the BVI, are to be tackled and brought to an end. If the abuses were allowed to continue, then, in my view, they would put at severe risk steps towards self-determination as a modern democracy to which the people of the BVI are entitled and wish to take. Let there be no doubt, I have not recommended suspension of part of the Constitution to frustrate the hopes and wishes of the people of the BVI, but rather to give them an opportunity to fulfill those aspirations. They deserve no less. 14.8 As I have indicated, whilst the length of the suspension will depend upon a wide variety of factors, including, possibly, the time that the review of the Constitution I propose may take, the suspension should be for as short a time as needed to allow for the re-establishment of elected government, subject to the principles of good governance. I recommend that, initially, the suspension should be for 2 years, but subject to extension or early termination as circumstances dictate. 14.9 Such suspension would include both the cessation for the time being of ministerial government and the dissolution of the House of Assembly. During the period of the suspension, I recommend direct rule by the governor with the assistance of some form of advisory council to advise him on the formulation of policy and the exercise of his functions. The advisory council should reflect civic society and take full advantage of the pool of experience, expertise and wisdom within the BVI. 14.10 A suspension of that part of the Constitution will, of course, impose a greater burden on the governor and his office. It would require substantial strengthening of the governor's office in terms of both numbers and seniority of staff, as well as administrative support and facilities. However, whilst I did see public officers under pressure, I did not find any information that senior public officers are or may be systemically dishonest. Far from it, I saw generally talented, able and committed people, in whose hands I consider the public service would be safe and could be effective. In my view, they would be able to bear the additional burden that my proposal would involve. Even if, in some areas, expertise and advice is required from outside, in supporting any temporary arrangement as I have proposed, I would recommend and urge the governor primarily to draw upon this invaluable pool. Recommendation A1. I recommend partial suspension of the Constitution, by the dissolution of the House of Assembly, the cessation of ministerial government and necessary consequential suspension of provisions of the Constitution, for an initial period of 2 years. During that period, I recommend direct rule by the governor with such assistance as he considers appropriate, e.g. an advisory council to advise him on the formulation of policy and exercise of his functions. That council should reflect BVI civic society. In the period of the temporary constitutional arrangement, I also recommend and urge the governor to draw upon the pool of public service talent in the BVI to advise and aid him. In that period, the governor should have all necessary executive powers, including the power to make any public appointments. I recommend that there should be a return to ministerial government and an elected House of Assembly as soon as practicable, and the governor should regularly, and at least every 6 months, take advice from any advisory council and or from whom otherwise he considers appropriate as to the earliest practicable date on which such government can resume. The governor shall publish a report on that issue at least once every 6 months. Constitutional Review. 14.11 Second, and again looking to the future, I have concluded that a constitutional review is also essential. The last such review was held in 2006, and led to the 2007 Constitution. The COI has demonstrated that that Constitution cannot take the weight it has to bear. Indeed, although there may have been significant differences in the reasons for this, no one suggested that the Constitution is working. In my view, a review is required to ensure, so far as possible within any constitutional framework, that mechanisms are put in place so that abuses which I have identified cannot continue or be repeated, but also that the needs and wishes of the people of the BVI, including their aspirations for self-government, are met. To meet those requirements, the review must be focused, open, inclusive and expedited. 14.12 Such a review has, of course, been in the wind for some time. Nearly 2 years ago, the Premier announced that a Constitutional Review Commission was to be established, to report within 6 months. However, appointments were not made until December 31, 2021, the detailed terms of reference have not been published, and the time for the Commission to report has been extended to an initial 2 years, i.e. by January 2024. It is not for me to set out the detail of how the review should be conducted, but it is essential that the members of the review team are drawn from a sufficiently wide constituency, and that its terms of reference are sufficiently robust and forward-looking to ensure the abuses I have identified are mended and cannot recur, and the aspirations of the people of the BDI can be met, and met within a timeframe that is as short as reasonably practicable. 14.13 As to terms of reference, these must be broad, but in my view, amongst other things, the Commission should consider the following. 6. How the executive ministerial government can be held to account in the House of Assembly, e.g. by some different structure, number and/or configuration of seats, and/or in other ways, and how the elected dictatorship of the Premier, i.e. current constitutional position of the Premier, which gives him or her largely unrestricted powers in practice, might be mitigated. 1. 7. Whether the current constitutional pillars of governance are sufficient, and in any event how those independent institutions can be effective. 8. The powers that need to be reserved to the governor, and how issues as to the exercise of devolved and reserved powers respectively, when they arise, are to be resolved. 9. A mechanism for the transfer of reserved powers to the devolved BDI government in the future, without a further change to the Constitution being required. 2. X. Whether there should be a regime in relation to election expenses in the form of, e.g., a requirement on election candidates to submit a breakdown of expenses, including donations above a specific sum and/or a cap on such expenses. 3. 11. Whether statutory boards should be embedded in the Constitution and, if so, whether there should be a statutory boards commission. 4. And 12. Whether the Speaker should continue to be a political appointment, or whether he or she, even if elected, should be independent of the political parties. 5. 14.14 It should also consider how best the law enforcement agencies can sit within the constitutional framework. Either as a strand of the constitutional review, or as a separate review running in parallel, I recommend that there be a review of the law enforcement agencies and justice agencies, with a view to ensuring that the law enforcement and justice systems are coherent and fit for purpose within the context of the BDI today. 14.15 Particularly because it may be challenging to re-establish ministerial government and the House of Assembly without changes to the Constitution, the constitutional review I propose should begin its work urgently, and conclude its work promptly. Whilst I know that such reviews often take longer, I propose that the constitutional review commences as soon as possible and concludes its business within a year, with the Governor having the ability to extend that time by no longer than 6 months. In that way, it is hoped that the review will not impede or delay the return to elected government. Recommendation A2. I recommend that there be an early and speedy review of the Constitution, with the purpose of ensuring that abuses of the type I have identified do not recur, and establishing a constitution that will enable the people of the BDI to meet their aspirations, including those in respect of self-government within the context of modern democracy. That will require a constitution that is sufficiently robust to ensure adherence to the principles of good governance within government, but also enables the progressive development of the BDI's own political institutions. The constitutional review I propose must be broad. Without restricting its ambit in any way, in my view, it will need to address the following issues, amongst others. How the executive ministerial government can be held to account in the House of Assembly, e.g. by some different structure, number and/or configuration of seats, and/or in other ways. 2. Whether the current constitutional pillars of governance are sufficient, and in any event how those independent institutions can be effective. 3. The powers that need to be reserved to the Governor, and how issues as to the exercise of devolved and reserved powers respectively, when they arise, are to be resolved. 4. A mechanism for the transfer of reserved powers to the devolved BDI government in the future, without a further change to the Constitution being required. v. Whether there should be a regime in relation to election expenses in the form of, e.g., a requirement on election candidates to submit a breakdown of expenses, including donations above a specific sum and/or a cap on such expenses. 6. Whether statutory boards should be embedded in the Constitution and, if so, whether there should be a statutory boards commission, and 6. Whether the Speaker should continue to be a political appointment, or whether he or she, even if elected, should be independent of the political parties. The constitutional review I propose should begin its work promptly, and conclude its work within a year or, if the governor is persuaded to extend that time, in 18 months. As a return to elected government will be difficult without constitutional reform, I regard the time for this review to be concluded to be of the essence. The constitutional review I propose should be established by the governor. I am aware that a constitutional review commission has been recently set up by the elected government. Its membership has recently been announced, but, so far as I am aware, its terms of reference have not yet been determined. It has an initial period of 2 years to report. Whilst that commission may be a basis for proceeding with the constitutional review I propose, whether its membership, terms of reference and timetable remain appropriate are matters that now need reconsideration. Curtailment of open-ended discretion. 14.16 In considering governance within government, I have identified a significant number of areas where an elected public official, usually a minister, exercises an open-ended decision-making power. Sometimes that power is granted to that person, sometimes it is simply abrogated. The existence and use of such powers is contrary to good governance, and perhaps more than anything else I have seen gives rise to a risk of not only poor decision-making, but also dishonesty. 14.17 In my view, there is an urgent need to review all such discretionary powers, and remove them or, where they are deemed necessary, ensure that they are exercised in accordance with clearly expressed and published criteria. I have made some specific recommendations about powers in the particular areas I have looked into. Drawing specific recommendations together, I therefore recommend a general review to curtail such powers. Recommendation A3. I recommend that there be a review of discretionary powers held by elected public officials, including cabinet, with a view to removing the powers where they are unnecessary, or, where they are considered necessary, to ensuring that they are exercised in accordance with clearly expressed and published guidelines. This review could be conducted by a senior BVI lawyer or retired BVI/East Caribbean judge. Audits and investigations. 14.18 The final recommendation is burdensome, but relatively straightforward. It flows logically and inevitably from my findings in relation to the matters into which I have inquired, as set out above. It is again, in my view, essential. Whilst I regard the future as more important than the past, I have concluded that a proper, independent and impartial audit should be undertaken in relation to government decision-making and expenditure, mainly, but not exclusively, in the areas of government into which I have looked. 14.19 This is vital because, not only do those who live in the BVI have the right to know, but also further steps, such as criminal prosecutions and the recovery of public monies wrongly expended, will be crucially informed by such investigations. Where such steps should, in my view, be considered by the relevant BVI authorities, notably the COP and DPP, now, without the need for any further audit, I have said so above. Where such investigations are recommended, a report of the Auditor General, or the independent person or body she appoints to conduct it, then the COP and, in her turn, the DPP will consider whether such steps are in the public interest. 14.20 My inquiries have shown that almost every aspect of government in the BVI has very poor governance, but, in recent years, the efforts of the Auditor General and IAD Director to investigate and report have to a large extent been thwarted, and, where they have reported, their observations in respect of the possible consequences of such poor governance and their recommendations have, in almost all cases, been ignored. That means that the areas which I identified as being in need of investigation and audited are legion. I am very well aware of the potential burden that this proposal may put upon the Auditor General and, in due course, the COP and DPP. 14.21 I therefore recommend that the Auditor General, together with other independent persons or bodies instructed by her to assist, as soon as possible initiate a short review of all areas of government, including, but not restricted to those identified in this report, and prepares a timetable for the audit of appropriate areas and reports to the governor accordingly. The governor should ensure that sufficient resources are available to her to undertake the audits as they arise under that timetable. However, the initial review will of course require the prioritization, and possibly even the selection, of matters for audit. The Auditor General will be in the best position to make decisions as to such priorities and selections, but she may, for example, wish to prioritize areas which, in her view, may be more likely to give rise in due course to further steps, e.g. in relation to criminal investigation and/or steps to recover public money. The Auditor General should report to the Governor with the results of that review as soon as possible, and in any event within, say, 2 months. 14.22 The audit reports, once complete, should be published on the Auditor General's website unless the Governor directs that they cannot be published, e.g. on grounds of national security. 14.23 Those reports should indicate where the Auditor General considers further investigations into possible wrongdoing should take place, and such reports should be sent to the COP as well as the Governor. The COP will then consider whether a criminal investigation is in the public interest. That proposal does not, of course, prevent the COP instigating an investigation into the circumstances of a matter involving public officials earlier, if he considers that is in the public interest. Any charging decision will be made by the DPP in the usual way, on the usual dual test, i.e. evidential and public interest. 14.24 As I have indicated, the COI did not have the facilities to conduct any financial investigations into either individual projects or individual people. In the light of my findings, I recommend that one or more independent units are established to conduct such investigations and take steps to ensure that any appropriate steps are taken to secure money, land or other assets pending the outcome of criminal or civil recovery/confiscation proceedings. I recommend that the units are responsible for any civil recovery proceedings. It will be a matter for the Governor, but it seems to me that at least the investigation unit might sit under the COP, but its independence, impartiality and integrity will be crucial, and steps should be taken to ensure that the people of the BDI can and will have proper confidence in it. Again, the Governor will need to ensure that the units, together with the DPP's office, are adequately resourced. As the audits which I have proposed proceed, the units will also need to work with the Auditor General's team. However, as with the audits, the COP and/or the DPP will have to make decisions in the public interest as to priorities and selection of matters for investigation and criminal/recovery proceedings. 14.25 I consequently make the following recommendation. Recommendation A4. I recommend that the Auditor General, together with other independent persons or bodies instructed by her to assist, as soon as possible initiate a review of all areas of government, including but not restricted to those identified in this report, and prepare a timetable for the audit of appropriate areas and report to the Governor accordingly. The Governor should ensure that sufficient resources are available to her to undertake the audits as they arise under that timetable. The review will require the prioritization, and possibly even the selection, of matters for audit. The Auditor General will be in the best position to make decisions as to such priorities and selections, but she may, for example, wish to prioritize areas which, in her view, may be more likely to give rise in due course to further steps, e.g. in relation to criminal investigation and/or steps to recover public money. The Auditor General should report to the Governor with the results of that review as soon as possible, and in any event within, say, 2 months. I recommend that the Auditor General, assisted by other independent individuals as the Governor thinks fit, thereafter proceeds to perform the audits in accordance with that timetable, as agreed with the Governor. The Governor should ensure that sufficient resources are available to the Auditor General to enable her to perform these audits expeditiously. Once complete, the report should as soon as practicable be published on the Auditor General's website, unless the Governor directs that publication should not be made, e.g. in the public interest. I recommend that the governor establishes one or more independent units to conduct investigations into projects and/or individuals as identified by the units, taking into account the information in this report, the audits that have been and will be conducted by the Auditor General and Internal Audit Department and, of course, information and intelligence that the units themselves gather. The unit should also be responsible for taking steps to secure money, land or other assets pending criminal and/or civil confiscation and/or recovery proceedings, if appropriate. They should also be responsible for civil recovery. The governor should ensure that sufficient resources are available to the units to enable them to perform their functions, and to the DPP's office, and any other enforcement office, in relation to subsequent steps taken in respect of criminal proceedings and steps to recover public money. Other recommendations. 14.26 In addition, I make 45 recommendations in respect of particular areas of government, including specific projects, which are set out at the end of the respective chapters of this report. It is unnecessary to repeat them here, they can be found listed in full in the summary of recommendations at the beginning of this report. These are all by way of particular requirements, as I see them, within the framework of the primary recommendations to which I have referred. Final observation. 14.27 I recognize only too well that the recommendations I have made are extensive, and will require huge effort. That is inevitable, as they reflect the work that I consider needs to be done. However, I appreciate that, even if the governor is minded to accept them in whole or in part, they will require prioritization and planning, so that the business of government can proceed in parallel. But I consider that they will be worth the effort and sacrifices that they will demand. 14.28 Despite their challenges, I commend my recommendations to the governor, and I encourage him to adopt them in full. This concludes Chapter 13, Overarching Recommendations. Please check for the other sections of the COI report.